All right, and I'm going to turn it over to Roger. Thank you, Roger.
Well, thanks, Sam, and good morning, everyone. My name is Roger Smerage. I'm a business and banking litigation attorney at the law firm of Ruberto, Israel and Weiner. And this morning, I am glad to be with you to present business law basics for every small business. Over the course of the next hour or so, I'm going to be covering a number of topics that every business should be thinking about from a legal perspective, even if you've never even talked to an attorney. Some people have a little bit of an apprehension to do so, but I promise we don't bite, and usually we're more helpful than you might even think. So with that, let's get started. Just before I begin, I'm going to put up the fine print. Although I am here as an attorney, this presentation does not form an attorney-client relationship. So if that's something that anyone is looking to do or to have some formal legal advice, I'm more than happy to have that discussion offline or after the presentation. But this morning's seminar is just for informational purposes only. So a little bit about me. I have litigated cases on behalf of businesses and banks in both state and federal court. My experience includes trying cases before both judges and juries. I've also argued appeals in front of the Massachusetts Appeals Court. I've represented businesses big and small across a variety of industries, including finance, real estate, construction, logistics, food service, tech, and wireless communications. I'm native to the area. I grew up in Hamilton. I live 10 minutes from where I grew up, and I currently serve as the town moderator in Wenham as well. And just briefly before I dive in, want to introduce everyone to my firm, Ruberto, Israel and Weiner, or RIW. We're about 25 or so attorneys across 3 main practice groups. Our office is in Boston, right by the aquarium. There's a lovely little picture of the building we're in on the slides. But we represent businesses all over the Commonwealth, and we have numerous clients up here on Cape Ann. Our 3 main practice groups are banking, finance, and lending. This covers our banking work as well as restructurings and bankruptcy services. We have a corporate and business practice, which does things like mergers, acquisitions, formation, licensing, real estate, and business estate planning. And then finally, we have our litigation practice, which handles lawsuits and other forms of business disputes. Some of our unique practice areas where we combine these traditional practices include hospitality law and cannabis law. And most importantly, we are a proud member of the Greater Cape Ann Chamber of Commerce. So what will we be covering today? We're going to cover at a very high level 8 different topics. These include business entities and the various formation options when you're organizing a business or thinking about how to reorganize a business, organizational documents and other governing legal documents. These are really important to have. Sometimes you're required to have them. I'll go over all that. Client-facing documents and when those are helpful. Real estate issues, employment issues, data privacy, which is something that every business should be thinking about, even if you don't traditionally think of yourself as a tech or data-heavy business. Intellectual property, and then finally, business succession planning. So let's start with business entity types and formation options. And I'm going to focus my discussion today on Massachusetts law, just because we're all here in the Commonwealth, but some businesses that are located in the Commonwealth might have chosen to organize under other state law, and that's perfectly fine. And, there may be some differences, for example, if you're organized under Delaware law for some reason, there's slightly different duties and obligations. But at a high level, this discussion will be applicable to businesses wherever they're organized. So Massachusetts law provides several different types of formation options. And these have varying levels of formality and limitations on liability for the owners of the business. First, corporation. A corporation is the traditional form of business. It's the most formal. This is where you have shareholders, a board of directors, meetings, minutes, bylaws, things like that. Massachusetts does recognize what is called a close corporation, and that's what typically small businesses would fall under. You only have a few shareholders. There's no public trading of the ownership. You're not listed on a stock exchange or anything like that. And these close corporations carry very high levels of duties shared among the shareholders. So for under Massachusetts law, shareholders in a closed corporation have what's known as the highest and utmost duty of loyalty to each other. What that means is when you're operating this type of business, you have to be thinking about the business first. You can't be taking business opportunities for yourself personally. Can't engage in self-dealing, things like that. So that's what most small businesses fall into if they're in a corporate formation. Now, you may have heard the terms C Corp, S Corp, B Corp, wondered what those are. C and S corporations, that refers to a corporation's tax status. So a C Corp pays income tax directly, while an S Corp passes through its tax liability to the individual shareholders. It's more of an accounting issue than a legal one, but it's something to be aware of. And typically a small corporation would be an S Corp. You would have it set up so that the tax liability passes through to the individual owners, and that's reported on K-1 statement, things like that. A B Corp is actually not a separate form of corporate status, but that's actually a certification that a for-profit company can obtain from a nonprofit organization called B Lab. You can obtain it for a fee, and it simply reflects that the company meets certain standards for sustainability, environmental compliance, accountability, transparency. It's essentially a marketing and goodwill type thing. You might see B Corps, they are allowed to print out the little B Corp poster and put it in their shop or in their storefront. But it doesn't actually change your legal status. So that's what a B Corp is. For what it's worth, B Labs, the entity that certifies B Corps, requires a prospective corporation to be what's called a benefit corporation under state law. There's certain requirements that a company needs to have met to become a benefit corporation, things like factoring their impact on society, their workers, the community, and their environment when determining what is in the best interests of the company. So moving on from corporation, the next entity type is a professional corporation. This is basically just a particular type of corporation that operates in a certain professional service realm. So you can think of law firms, medical practices, accounting firms. Those are sometimes set up as professional corporations. The next traditional option is the partnership. So this is a lot less formal than a corporation. It's basically just an association of two or more individuals, the partners, who decide to carry on a business for a profit. Again, usually this is something that law firms or small legal practices or small medical practices sometimes use, but it's not limited to that. Any prospective business can form as a partnership. And when I get to organizational documents, I'll talk a little bit more about why you might look at partnership versus a corporation. Limited partnership is only different from a regular partnership in that you have different levels of partners. So you have general partners who might have more rights within the organization, but also more obligations. And then you also would have limited partners who might, just be providing financing, and their obligations and rights are limited as a result of that. Finally, you have the LLC, and this is probably the most common form of business entity now. Maybe some of the people, maybe some of you are organized as LLCs. This is a hybrid form of business that was developed in the 70s and gained popularity throughout the 80s and 90s. It provides more limitations on liability without quite as much formality as a corporation. LLCs actually can apply for B corporation status as well, if that's something that you're interested in. B corporation status is not actually limited to just corporations. There are different requirements for an LLC, but that's an option for LLCs too. The key when thinking about business formation options is to select one of these options and not to operate as a sole proprietorship. The risks that are attendant with operating as a sole proprietorship are more significant than when you're operating as any of these business entity formation options, because your personal assets have little to no protection from creditors from the business. Essentially, a sole proprietor is just doing business on their own personally, and so all their personal assets are potentially available to creditors if the business incurs significant debt. So you always want to kind of avoid that. And whether it's a corporation or a partnership or an LLC, all of those options help shield your personal assets away from business creditors. Turning next to organizational documents. Each form of business has certain documents that are required to create and maintain the business, as well as some optional documents that can help avoid conflicts within the business. When you're operating business, it's also always important to think about conflicts that are external, but also conflicts that may be internal among the owners of the business or different stakeholders of the business. So for a corporation, you're required by law to have articles of organization that are filed with the Secretary of the Commonwealth. And these articles cover things like the number of shares, how shareholders may sell or transfer their shares. So it's pretty bare bones, but it's the essential structure of the corporation. It also helps to have some optional legal documents like bylaws and a shareholders agreement. These provide more detail on how the business would operate, what obligations the shareholders owe to each other, things like how many directors, how often directors meet, what the directors have to report to the company can be covered in bylaws. And if the shareholders want to alter the duties that they owe to each other, things like that, that's what a shareholders agreement can do. For a partnership, while a partnership agreement is not required by Massachusetts law, there are certain default provisions under state statute that would govern the management of the partnership in the absence of a partnership agreement. Such an agreement can be an invaluable resource to avoid disputes among the partners, or if disputes do arise, for providing a method for resolving them. And then an LLC is a little bit more like a corporation when it comes to organizational documents. You do have to file a certificate of organization with the Secretary of the Commonwealth, but for an LLC, that certificate is actually even more bare bones than a corporation's articles. And typically you would draft an operating agreement that can provide detail about which members are responsible for managing the LLC, for example, and what other rights and responsibilities exist among the members of the LLC. And I'll just pause here to, make note that in an LLC, you don't have shareholders or directors. You have members who are the owners of the LLC. And then you have managers who are the equivalent of the directors of a corporation. Typically, the managers are members, and within that operating agreement, you would specify, which of the members are managing members and which members aren't, and again, what their various duties are. I'll touch just really quickly on client-facing documents because not every business is required to have client-facing documents, and not every business necessarily needs client-facing documents. But it's important to think about what documents you might need for client interaction, regardless of what your business is, and whether any of those documents are legal documents like terms and conditions. Some businesses are required to have terms and conditions. Heavily regulated businesses like financial institutions, insurance companies have to have certain types of terms and conditions that govern their relationship with their clients. But even for businesses that don't have to have terms and conditions, you might want to consider whether they provide you protection in certain circumstances. So, for example, businesses that provide goods to consumers, you might want to spell out the nature and limits on any warranties on those goods, or provide specific methods and locations for dispute resolution. For businesses that provide business-to-business services, it actually may be critical to dictate the terms of those services. And if you're doing so through sales forms, you might want to think about putting standard terms on the back of your sales form, because entities that you are doing business with, they might have their own standard provisions. And if you don't have yours, then theirs are going to govern. At least if you have yours, and then there's a dispute, then the law provides methods for figuring out which set of terms would apply. But the thing that is really critical here is making sure you're not letting other people dictate the terms of your transactions. For example, one key term to consider is if you want to be able to recover attorney's fees in any business dispute, you usually need a contract term that spells that out, because the law provides in most instances that each party in a dispute has to cover its own attorney's fees. There's only very few circumstances in which Massachusetts law and American law in general provides that the winner of a legal dispute gets to recover its attorney's fees from the other side. So if that's something that's important to you to cover that expense, or at least prospectively cover that expense, then it's important to have a contract term that spells that out. So now we're going to turn to real estate issues, and we're going to spend a little bit of time here because one of the biggest decisions for any business is where to locate, both geographically and in terms of your physical needs for space. Maybe now post-COVID, a lot of businesses have moved to having less physical space, but it's still an important thing to be thinking about. And a critical question is whether to rent space or to buy it. Not every business has a choice, but if you do, there are a number of factors that go into the decision-making process. Do you want, as a business, to have to deal with a landlord? If you are dealing with a landlord, do you want it to be a corporate landlord, or an individual? What level of responsibility do you want to have over the management and upkeep of property? When it comes to commercial leases, landlord drafted leases are typically very landlord friendly. So things that you might see in those types of leases and want to be looking at carefully include rent escalation, common area management charges, maintenance, limitations on liability. And while the Massachusetts Supreme Judicial Court has recently narrowed the application of limitation of liability clauses in commercial leases, they're still there and they still apply in some circumstances. So even if you're not buying property for your business, if you're going to be renting, it's really important to review and actually engage in some negotiation over the lease. And this is an area where getting an attorney involved, someone who does commercial real estate leases, just to review and do some light negotiation, it can be a great savings in the long run. Sometimes spending a little bit of money up front can really help avoid disputes down the road that can cost hundreds of thousands of dollars. Another thing that landlord-friendly leases will often have is a personal guarantee from the tenant's principals. And personal guarantees, what they are is it's a provision that says that even though the business is entering into the lease, the owners of the business will be personally liable if the business itself can't pay the rent or other charges under the lease. So, that type of provision can put you personally and your personal assets at risk if the business isn't able to satisfy its lease obligations. Something to really be, on the lookout for. A lot of landlords will require this. It's basically a backstop for them. If the business, suffers or doesn't succeed. And it's not necessarily a bad thing to sign a personal guarantee. It's just something to be aware of and really, think about whether that's something that you're willing to do as a business owner. And actually, personal guarantees are something to be on the lookout for in any legal business documents. I'll touch on financing a little bit later, but when you're looking at a commercial loan agreement, for example, the business will be the borrower and the business will be the entity that signs on to repay the obligations. But a lot of times commercial loan documents will also have personal guarantees. So if the business can't repay the loan, then the individual signing the guarantee are responsible for it. Again, it's not necessarily a bad thing. It's just something to be aware of. I've got a client right now who signed a commercial loan document. She wasn't aware that she had also signed a personal guarantee as part of that. She shut the business down years ago, but did still owe some money. The business did still owe some money on a commercial loan, and now the company that bought the debt from the original lender is pursuing that personal guarantee, and there's not a lot of recourse that is available. If you sign such a guarantee, you're saying that you're going to be good to backstop the company from a debt standpoint. So just something to be aware of. Now, on the other hand, if you're going to buy real estate for your business, again, here's where financing is important to consider. In addition to personally guaranteeing a loan to buy commercial property, you want to be thinking about what form of security you have to provide. Residential loans usually only require that particular property as collateral. Commercial loans usually require more security than just a mortgage on the property that's being bought. you may have to give a security interest in the business assets, for example. You may have to give a security in any rents that you're going to be collecting if you're buying a property that has multiple units and other businesses will be tenants of yours. So you want to be thinking about what other collateral you might have to put up for that type of lending arrangement. As I said, maybe you're buying a property where you will also be the landlord for other tenants. If that's the case, then you might want to consider buying the property under the name of a separate holding company from your operating business. That way, the liabilities of the landlord and your operating business are two separate sets of liabilities, and you become a corporate landlord with one of the businesses, and you still have your operating business as a separate standalone business. Finally, regardless of whether you're leasing or buying, one critical thing to keep in mind from a real estate standpoint is whether the use that your business will engage in is legally allowed at the location. This can be something to consider either from a zoning perspective or other municipal ordinances. But if your type of business, for example, in some areas you can't operate a restaurant for whatever reason, whether it's zoning or otherwise. If you're looking to operate a restaurant where a restaurant is not permitted as of right, then you might have to go and seek a special use permit from the town or city in which you're looking to operate. And depending on the municipality, this can be a challenge. Some towns and cities are more willing to grant special use permits than others. That's just the way of life. But that's something to be thinking about. And when you're doing your due diligence about where to operate your business, to look at whether there are any restrictions on use of that particular property. So I want to turn now to employment issues. If you have employees, not all businesses do, but if you do, you need to be thinking about what you have to have in place from a legal perspective. Obviously, there are OSHA requirements. You have to post certain notices in conspicuous areas of your business, but it's also important to have an employee handbook. It's a key document. Now, it's not a contract, but it provides clear guidance for employees and outlines what their rights and responsibilities are. It's basically a set of expectations that you as the business believe that the employee should adhere to, and can really make a difference if you run into issues with an employee down the road. If you have a handbook that clearly delineates what certain conduct is permitted and prohibited, you can point to a handbook and say, here it was clearly laid out that XYZ is not permitted on company time or while you're at work, and so here's where we have an issue. This is another place where spending a little money up front, working with an employment lawyer can really go a long way in protecting a business from messy disputes, costly disputes down the road. Now, Massachusetts also has 2 employment statutes that every employer should be aware of. There are certainly others, but these are 2 major ones. One is the Wage Act. The Wage Act governs the timing and method by which employees are paid. Now, there are different requirements depending on whether employees are paid weekly, bi-weekly, semi-monthly, and those are all spelled out in the statute. But it's important to be aware that that statute exists and those requirements exist. and to know which ones apply to your business. The Wage Act also prohibits employers from retaliating against employees who lodge complaints under the statute. So that's something, to really be aware of, that in addition to underlying Wage Act complaints, if you take adverse action against employee for exercising their rights under the Wage Act, that can also expose a business to liability. And unlike many civil statutes, the Wage Act can actually give rise to individual liability for business owners for acts taken on behalf of the business, because the term employer in the statute includes the business's principals, so its owners and its officers. Just, pretty important to be aware of that as well. And in the last couple of years, Massachusetts enacted the second statute that I want to talk about, which is the Paid Family and Medical Leave Act. You might have heard about this, especially at the start of the pandemic. This was a very common topic, both because of the impact the pandemic was having on people and the fact that it was a new law. This is different than the federal FMLA, which everyone might be aware of. The FMLA has certain exemptions. For example, a business that doesn't have 50 employees is not covered by the federal FMLA, but Massachusetts, the Paid Family and Medical Leave Act doesn't have an exemption for size. So even if you just have one employee, you're covered by the Paid Family and Medical Leave Act. And employees are generally immediately eligible for the benefits provided under the Massachusetts statute, whereas the FMLA doesn't provide eligibility until a year after employment. Finally, a big distinction, which maybe you're aware of, the Massachusetts Paid Family Medical Leave Act requires employer contributions. Those aren't required under the federal FMLA. But it does mean that businesses that have employees who are covered have to pay in. And, there's a set of regulations that, cover that as well. One other thing on employment that I just want to highlight is that Massachusetts has a very narrow definition of independent contractor. In the past, a lot of businesses used to try to characterize their workers as independent contractors to avoid paying things like benefits, or to avoid having to pay, income tax, through withholdings, and force the so-called independent contractor to pay their own income tax directly. Massachusetts has, through the courts, it's not a statutory thing, but it's a thing that courts through cases have decided, is to really limit what type of worker can be considered an independent contractor. There's a whole list of 15 or so factors that have to be looked at to decide whether an employee, or a worker, I should say, is an employee or an independent contractor. But things like, how much time are they on the job? Do they work for other employers? Do they set their own schedule? Things like that are all factored in making that determination of whether someone is an employee or an independent contractor. It's just, good to know that, whereas in other states, maybe you can get away with characterizing someone as an independent contractor. In Massachusetts, you have to be really careful about trying to do that. All right. So data privacy. It's a huge issue. It's a huge issue for a lot of businesses that don't even realize it's a huge issue for them. And while many aspects of business and commerce are regulated at the federal level, data privacy isn't one of them. Not yet. There are, proposed bills every session of Congress looking to cover data privacy, but so far none of them have, gained traction. But Massachusetts has enacted a data privacy law, and in 2009, the Attorney General promulgated regulations regarding the protection of personal information for Massachusetts residents. And personal information includes a resident's name in conjunction with a social security number, a state-issued ID number, a financial account number, or a financial card number. So, credit card or a debit card. So if you're holding that type of information, let's just say you're holding a resident's name and social security number, you are within the purview of the data privacy law. And that personal information could be either of employees, customers, or anyone else. So it doesn't have to just be, outside customers, it can be employees. So if you have a record of employees' names and driver's license numbers for whatever reason, maybe, you operate a fleet of cars that for your or trucks for your business, and you've required your employees to give you their driver's license numbers when they're doing, driving routes for you. If you have that information, you're covered by the privacy law. And in addition to complying with the provisions of the law and the regulation for any breaches of personal information, the regulations also require you, if you hold that type of information, to maintain what's called a written information security program. And this document, abbreviated as a WISP, will spell out how you go about protecting that information and who you designate among your employees or your team as the person who's in control of that information and is the contact person for the Attorney General. So that's briefly Massachusetts privacy law. It is also important to be aware of the data privacy laws of other jurisdictions, even if your business is only located in Massachusetts, because some of those jurisdictions have laws that protect their residents when they interact with businesses in other states. So at least as of the end of last year, according to the National Conference of State Legislatures, 5 states have enacted comprehensive data privacy laws, and these are even more rigorous than what we have here in Massachusetts. So those states are California, Colorado, Connecticut, Utah, and Virginia. And you might be surprised to learn that your business might even have to comply with the European Union's General Data Protection Regulation, the GDPR, which governs both data safety and data usage. The GDPR reaches non-EU businesses that collect even things like email addresses of EU residents, but its reach may be limited if the business in question doesn't actually offer services in EU member states. But it's something to be aware of if you're interacting with people from Europe. It's good to check to see whether you are covered by the GDPR, because the GDPR has some pretty rigorous requirements. In the last couple of years, you might have seen when you're using websites or Facebook, a lot more pop-ups about tracking cookies and things like that, and whether you accept that use or whether you want to manage that use. That's a result of the GDPR, even though, you know, we're sitting here in the States. So that's data privacy briefly. Next, I just want to quickly touch on intellectual property. It's important to consider the difference between state and federal law and intellectual property. Some IP is governed exclusively by federal law, things like patents. Trademarks, on the other hand, are governed by a combination of state and federal law. And the difference is patents cover inventions, things like that. Copyrights, also governed by federal law, cover things like writings, which is actually a broad category. It can include things like architectural designs, audio recordings. Trademarks, on the other hand, is all about branding and you know, what your logo is, what your word mark, if you have one, is. Maybe you have a slogan that's unique that you want to trademark. As I said, that's governed by a combination of state and federal law. The federal law is called the Lanham Act, and that provides a baseline for trademark law. But some states create additional trademark protections through their state law. Massachusetts adopted what's called the International Trademark Association's revised model state trademark bill in 2006. So we have a pretty common approach to other states as a result of adopting that. And that sets forth some additional benefits beyond what the federal law provides. Just quickly, it's also important to consider the benefits of registering your intellectual property. In terms of like a copyright, for example, unregistered works have certain copyright protections, but in order to bring a civil lawsuit for infringement, you need to have registered your copyright with the U.S. Copyright Office. It's a prerequisite. Again, and the same is true for trademarks under the Lanham Act. In order to sue for infringement, you need to have registered your trademark, but the Lanham Act does allow holders of unregistered marks some relief as well. If someone is using your mark in a way that causes consumer confusion, you can sue for an injunction to prevent them from continuing to do so, even if you can't actually sue them for damages for infringement because you haven't registered. But it's important to, you know, think about registering, even though there is a cost to it. You know, if you want to be able to recover monetary damages for any infringement, you're going to have to have registered your intellectual property. It also helps just establish, you know, your claim to that intellectual property to show that it's been registered. Now, the last topic I want to cover this morning is business succession planning. And this is something that you might not think of as, you know, traditional legal topic. A lot of people don't think about the next steps of their business while they're operating their business, but it's really important to do so. Even if you're just getting your business off the ground, or you know, maybe you're expanding and bringing your business into a new phase, you really want to be thinking about business succession planning. For example, you know, are you intending to set up your business as a family business? Yeah. If so, do your children already work in the business, and do you have a plan to have them take it over? If so, you want this plan written out. You want it documented so that you avoid disputes down the road among your children over who controls the business and who owns what portions of it. Maybe one of your kids doesn't want anything to do with the business, but you want to make sure they're compensated, getting their fair share, so to speak, even though they're not going to be involved, because it's part of your legacy. You want to take steps to have that all documented ahead of time. Are you planning to run your business for a set period of time and then attempt to sell it to a larger business? Again, planning for that is really critical. If you have a plan for that, whether it's going to be a 5-year plan or a 10-year plan, you can set goals that you need to meet in order to position your business to be a good target for acquisition, and to have put documentation in place that provides an ease or a clarity when an acquiring business is going to be doing its due diligence as part of a potential acquisition. It's also important to have business succession plans if you have co-owners, partners, things like that, to ensure that there are exit plans that are documented, so that if anyone wants to leave the business, that's spelled out how that's going to happen. Or if they want to, if a partner or co-owner wants to leave their interests in the business to someone in their family rather than sell them back to the company, or leave them to a third party rather than sell them back to the company. Again, you want to have that all planned out. That way you're not dealing with that in an emergency fashion when someone decides, you know what, I'm ready to retire, but I don't want to sell my interest back to the company. I want, my son to come in, my daughter to come in, take a, step into my shoes. It's a lot better to have a plan for that rather than deal with it on the fly. And finally, it's an unfortunate reality of life that any of us can pass away at any time. And as a business owner, it's important to be prepared for that and to have a comprehensive estate plan that dictates what happens to your business or your share of a business. And, for example, if you're the sole member and manager of an LLC, does that LLC wind up and get liquidated upon your passing? Does it transfer to someone? Does it get put up for sale? All those things are important to be thinking about, and it's never too early to talk to someone about what your business succession plan looks like. And you can tie that into regular estate planning as well. So a important thing as a business owner to be mindful that your estate includes your business interests. So, all right, so that is everything that I wanted to cover this morning. I have some time. It looks 7 or 8 minutes for some questions. If anyone has them, I'm happy to answer them.
Yeah, if anyone online has a question as well, please, go ahead and unmute. Roger, I'll just start by asking, we talked about independent contractors versus employees. What are some penalties a business could face if they're classifying someone as independent contractor when they're doing that to maybe circumnavigate some rules and laws there?
Yeah, I mean, it's a good question, Sam. Certainly if you are misclassifying workers and you're not withholding income that you're supposed, income tax that you're supposed to withhold and report to both the IRS and the Department of Revenue, there can be penalties for that, I believe. I think I'm trying to remember if Massachusetts law also, I would have to look at this, but I seem to recall that there may actually be some potential penalties to the worker as well, particularly with respect to the failure to pay or provide benefits that they might be entitled to if they are misclassified.
Thank you, Robert. Anyone else? Any questions for Roger before we wrap this up?
No, it's very informative. Thank you. I have a lot of notes. Okay, that's great.
Yeah, thank you, Roger.
Well, thank you, everyone. I want to thank all of you for attending today. I want to thank the Greater Cape Ann Chamber of Commerce for letting me speak to you about these legal basics. Obviously, what we covered today was really high level. It's important to remember that law firms like RIW are here to help you work through legal issues in more depth. And even if it's just, an informal discussion, that's something that me and my colleagues are always willing to have, take a half an hour, whether you want to talk to our real estate attorneys, our employment attorneys. If you have any issues, we can always set up a call for, a half an hour to go over that, at no charge. And if I can offer, one piece of advice, it is to reach out to an attorney sooner rather than later when something comes up. Even if you don't think you need an attorney, and even after, consulting with one, it's clear that, legal services aren't necessary. It's always better to have that discussion early rather than to wait and have to hire someone, either on a whim or, while there's a mess, unraveling in front of you. If one thing in what I said, throughout the morning came through, it's always better to be prepared. My contact information is up on the screen. For those of you down at Harbor Loop, you also, I think there should be a handout with my information on it. Nice, excellent. And feel free to reach out, and I look forward to actually seeing people at the next chamber event in person again, or seeing folks at the next Coffee and Connections.
Well, thanks again, Roger, for your all your knowledge and your resources this morning. I'll just plug next Wednesday, February 15th. We're going to be having our monthly in-person networking event at Woodman's. They recently did some renovations over there. That'll be from 5 to 7 on Wednesday, February 15th. Again, that's going to be at Woodman's. So we hope to see you there. Thanks again, Roger. Thank you, everyone, for joining us. Have a great rest of your day. Take care, everyone.